Dr. Dana Tassone with participants in HFT 6228, a graduate course in hospitality management, and we're discussing Chapter 5. Chapter 5 has to do with employee relations and labor relations. In essence, what the chapter does is it breaks down the aspects associated with employee relations, and it also gives us specific aspects related to labor relations. A lot of people often confuse the two terms, and as you know, they have two very different meanings. Employee relations is very, very broad. It has to do with maintaining productive, positive relationships with the existing staff members within an organization. And that's done through a whole number of different programs that we'll talk about in the future. But this chapter introduces us to the concept of employee relations. I know I mentioned once before that a good deal of my personal focus, in addition to being the generalist in charge of the HR office, I would focus on legal compliance, and I also would work very closely with the people that we put in charge of employee relations, because this is the whole key. This is what differentiates strong HR practices from less than strong HR practices. So employee relations is a broad concept, and we'll touch on various aspects of it as we move along. Notice that at this point, obviously, we're introducing broad concepts, and then when we get into how to actually do it in later chapters, then we break it down into specific segments. So employee relations is a big concept. Labor relations is a very narrow focus. Employee relations has to do with maintaining productive, constructive relationships with the employee populace at large, and labor relations exists in a union house, a house that is represented by a third party called a labor union. And in labor relations, the entire focus is on the establishment and maintenance of collective bargaining agreements for those classifications of employees who are represented by a union. In some houses, all employees are represented by a union, and in some houses, just certain classifications are represented by a union, and then in others, there is no union. There is no union representation at any specific time. And as you may have noticed already in the wording in the book, when we talk about employment relationships, we're referring to the terms, rights, conditions, and privileges of employment. Those are the things that legal aspects apply to. Those are the things that the relationship aspects apply to. It's the terms, rights, conditions, and privileges of employment. And when we talk about employee relations, we're also really talking about the interactions among the groups of staff members. And the purpose of that is to ensure that we are being in integrity when it comes to what? The terms, rights, conditions, privileges of employment. So, I'm sure you've already noticed those terms are used extensively. So, when we talk about employee relations, an individual is recruited into an applicant pool. We then select qualified individuals from that applicant pool for specific positions. And when those individuals are selected, they are onboarded, they are brought on board, and they become new members of the organization. And of course, the very first thing that members of new organizations do, at least in proactive ones, is they attend a formal employee orientation program. The first document that employees are handed at that program is commonly referred to as the employee handbook. And the employee handbook is a document that is intended as the initial establishment of all the expectations regarding the rights, terms, conditions, and privileges of employment. And then later on, the book manual is used as a reference guide for situations that occur during the employment relationship that require a policy interpretation. And the employee handbooks reference to, let's say, employment at will status. In some cases, and you know that one exception to employment at will is the existence of a contract. So are union employees employees at will? No, they're not. They're covered by a contract, in addition to all the other exceptions that we discussed. Well, in some states, you have an organization, and the organization doesn't have a union, and they want to provide the expectations for performance and communications with the staff members. And the courts in that state, California comes to mind, the courts in that state have deemed that the existence of an employee handbook establishes an implied in fact contract. It's not an express contract, it's not written as a contract, it's not written as an employee agreement, but the information within it establishes the existence, in the eyes of the courts in that state and others, of an employment contract, an implied in fact employment contract. So what would happen from a legal advice perspective, an attorney would advise to not have handbooks. Don't abolish handbooks, destroy the ones you have, and because that way you won't have the existence of a contract, which is true. But on the other hand, is it sound employee relations? Is it the sound of management of employees within an organization to not establish and communicate and provide information regarding the employment relationship? And from a management perspective, of course, we would say no, that's not the right thing to do. And so how do you get around that? Well, there are ways to get around that. But in an employee handbook, or in a state that finds handbooks to be contracts, let's call them guidelines, or employee frames of reference, any kind of euphemism, whatever. Within that book, it begins with a declaration of rights. It begins with the declaration of rights, not of the workers, but of the employer. And the reason that this is important is that it in the private sector, an employer is entitled to any right as long as they establish it up front, in writing, and communicate it, and abide by it among their employees. And so, and in the absence of such rights, the employer does not have any rights for matters such as search and seizure, contraband, and those types of situations. Now, this is the private sector. and a lot of times people confuse when I say private sector and public sector. Private sector is a non-government entity. Public sector is a government agency or entity. Public sectors have constraints with regard to employer rights because of constitutions, U.S. Constitution and state constitutions. And so as a result, their guidelines, their rights, would be limited within the framework of those things that the government can or cannot do relative to protections afforded to the people by the Constitution. And so people just don't know because they just assume, okay, you have a handbook, well, and you have these documents. You know, we have standard operating procedures. I give you a figure that identifies all of the documents that should be present in a healthy organization, and what a lot of people don't know is that these documents aren't just made up out of thin air. It's like when you do research, it's not just made up out of thin air. It's substantiated by sources, and there are sources for every document that an HR office generates, and those sources are the strategic plan and the aspects that flow from it within the organization, and that's how you get your job design, job analysis, job descriptions, job specifications, all things that we're going to talk about later when we get into specifics. And so, like we said in the very beginning, HR management is a strategic force. It's a strategic. It is part of the strategic direction of an organization, and that strategic direction is the sourcing for any document that the HR office may create. So further down in the chapter, we talked a little bit. Remember, we talked a little bit about the EAW, the Employment at Will concept doctrine, common law doctrine, and we go into it in more detail in this chapter. And we start to identify exceptions to this eroding doctrine. As you know, it was a broad doctrine in its day, and over the years, it has eroded, and it continues to erode every day, every year. And one of the factors that governs an employment at will doctrine is another common law doctrine called the covenant of good faith and fair dealing. So, for instance, as we know in its truest form, the employment at will doctrine says that the employee has the freedom to work for any employer of its choice. The employer has the freedom to choose any employee of its choice. Either party can separate the relationship at any time, for any reason, with or without notice. And that's the end of it. And some of you have already figured out, well, you know, the advantage kind of is for the employee, because, you know, how many times do you see employees just you know, not show up to work anymore, and you know that they truly are free to come and go regardless of what we say about it. Well, the covenant of good faith and fair dealing says that that's not how you really do it. It says that you can't, or not you can't, you should not, and should not is always interpreted as can't in the courts. You should not terminate an employment relationship without a reason. The covenant of good faith and fair dealing says that you should not terminate an employment relationship without notice. And then, so of course, that gets into the definition of notice, and notice with an hourly wage employee would be the equivalent 1 hour of wages in lieu of notice. Pay periods for managers would mandate. We never advise HR organizations to document annual salaries. We have them document those salaries by pay periods, and so the reasonable notice period would be 1 pay period. And the hedge that an employer has is another tort law concept known as job abandonment. And those of you who have been involved in unemployment compensation cases will recognize that this is probably the #1 defense for an employer to not pay an employee unemployment compensation. And I think you know that why wouldn't the employer want to pay it? Because if the employer does pay it, the funds come from the government. But the employer pays into the fund, and the fund is established based on experience. And the higher the experience of claims, the higher the rate. And the lower the experiences, the lower the rate. And the goal is to pay the minimum rate, absolute minimum rate, which is a contributory type of social program. So, and then of course the other, not statutory, tort restrictions, unwritten restrictions, are matters of public policy. Refusing to engage in something that's a detriment to the public or not in the interest of the public. Whistleblowing is another example. If an employee goes to a government agency and identifies practices that are inappropriate, possibly illegal, those are not appropriate reasons for discharging an individual. Now, another thing, and I'm just running through these things just to go through them. As I told you in the beginning, you graduate students, I don't read the chapter to you. I don't outline the chapter. You've already read it, I hope. And so you establish these policies and say, okay, we established these policies, but in the practice of things, you made some exceptions. You made an exception here, you made an exception there, you made an exception there. What you've done, again, in tort law thinking, in common law thinking, what you've done is you've now created for yourself a binding past practice. So even though the paper says that this is the policy, a party would say, yes, you say that's the policy, but here's what you did this time, and this time, and this time, and this time. Therefore, you set a precedent of binding past practices. And those practices shall be binding on future decisions of relative nature. Another people so often they catch a phrase and they use it and sometimes they just throw the terms around. They really don't know the meanings of these terms, and the meanings are subtle. That's why in the book there are those little sidebar things that refresh the definitions of the terms, because in these terms they have specific meanings, and somebody will say, if somebody hears the term just cause, and that's a certain level of responsibility, and it really is a relatively low level of responsibility to explain an employer's discharge or termination action. Just cause is the term, which really just means a reason that is not illegal, a reason that is equally applied to everybody to avoid a past practice claim, a reason that is within the employer's established Bill of Rights, if you will. That's not what we call it, but Bill of Rights, and one that would make sense to an objective third party. That's just cause, you know. And I think in the next chapter, maybe the one after that, we're going to get specifically into the matters of tort law. And that's where we're going to talk about the different levels of responsibility and liability and those types of things. That's a pretty interesting chapter. Of course, I wrote. But anyway, it is advisable, and it says this in this chapter, it is advisable for an organization to have in place multiple tier reviews. First of all, to have a progressive disciplinary action policy and practice. Progressive means first warning, second warning, third warning. No such thing as a verbal warning. Remember this for testing purposes. We call it a verbal warning, but everything is documented. So it's really, in my practice, it was first warning, not verbal. First warning, second warning, third warning. If you verbalize something, you didn't document it, you didn't, get anybody's approval on it, it doesn't exist. Now you're up for the first one. First, second, and third. So, and you would then also provide a process, a practice called due process. Very similar to courts for social reasons. And so what you're doing is you're establishing a policy, and the policy permits individuals to defend themselves against any allegations of, there really are only two issues for discipline in an organization. It's either misconduct, you broke the rules, or it's a performance issue. You failed to meet the standards for performance. So, and in either case, there's a process afforded to you. You're told about it on the very first day, where you can defend yourself against any allegations of these things by presenting evidence to the contrary. And so we, in the last chapter, we saw statutes, employment at will up here. And then we saw statutes. Okay, those are exceptions. Now we're eroding the doctrine. And now in this chapter, we're still just touching the face of it. In this chapter, we see more exceptions to the employment at will doctrine. Remembering that the employment at will doctrine, that was the very first basis of employment relationships. So it's eroded by statutes. It's eroded by public policy. It's eroded by common law torts having to do with fair dealing. And as we'll see in the next chapter or the next couple of chapters, there are further and further and further erosions to that doctrine to protect people. And so that's, in a nutshell, that's employee relations. In a union shop, in a union house, there's an important specialty called labor relations, and labor relations has to do with union negotiations. If a union comes into an organization, the union represents, it's a third party. Union is a third party. It represents an organization. The rules for union practices are established by the NLRA, National Labor Relations Act, and the agency, the technocrats, are called the NLRB, National Labor Relations Board. They're the ones who make the rules, and when a union comes into an organization, the organization establishes a collective bargaining agreement. And that agreement becomes the mandate for the relationship of represented classifications of employees. It's a contract. And that contract is renewed usually usually 3 years, every 3 years, or every 2 years, every 3 years, and the contract is then modified in negotiation. And and when that happens, you have two sides. You have management and you have union. So you have union versus management, or management versus union. And once the chapter tells you the whole process, a majority vote, how you bring the union in, and so the management incurs the burden to bargain in good faith when establishing a collective bargaining agreement. The collective bargaining agreement is established. It is then ratified by the employees, majority of the employees, and then it becomes the agreement. And when negotiations or new negotiations or renegotiations come, and there is no opportunity to move forward in good faith, that's called an impasse. And when an impasse occurs, then both parties bring in individuals for conciliation or mediation so that they can go on with the process. And there's no right or wrong. Some people say, "Oh, unions are bad," and I give you the history of it. Unions still make a lot of sense. And then other people will say, "Oh, unions are really, really good." And the answer is, a union is good or bad. You know, if you're a manager, I've been on both sides of both types of houses, and you know, if you're a manager and you're working in a union house, you have a big advantage. The big advantage is every single itsy bitsy aspect of employment expectations are articulated in the contract, the collective bargaining agreement. So you just go by the contract. It makes it real easy. And of course, in a non-union house, the advantage is that managers have much more leeway because there isn't tiny specific rules of do's and don'ts. Neither one is bad. They're both good, and there's good and bad for both workers and managers in both cases. All has to do with really the organization itself. And so we're out of time. But anyway, here's the thing. Employee relations, big, wide, huge. Something we'll talk about a lot. Labor relations, specified, very narrow, very specific. Has to do with specific relationships. If you have an individual or an organization that has a union, and let's say all the employees are represented by that union, does that mean that you have labor relations and not employee relations? Absolutely not, because the power is in the employee relations. So employment relations will always exist, and the better it is, the better the health of the organization is. And where there's a need for labor relations, that exists within the umbrella of employee relations. And that's just some thoughts on those topics, and as I keep saying, much more to come, and we're out of time. So see you in the next clip.